Welcome everybody to 29 Bedford Row. We've been asked to come and talk to you today about coercive or controlling behaviour. Not that any of us suffer from that. We're very pleased to be able to talk to you today. It's an interesting topic because it's an issue that we've all been addressing and looking at in terms of domestic violence, and particularly how to manage allegations of coercive or controlling behaviour and how it impacts in child arrangements and orders around family law protection. What we're going to do today is try and talk about the impact of those decisions and that approach in terms of financial remedy. And the question we're asking is whether conduct can incorporate the allegations of coercive and controlling behaviour. Does the Matrimonial Causes Act, the meaning and definition of conduct, encompass controlling and coercive behaviour? And if it does, how do you measure it? How does the court find evidence? And if the evidence is proven, how does that impact on outcome? We're going to go through some of the more recent decisions and talk about the history of conduct generally. I'm going to just touch upon the Children Act cases and introduce how coercive and controlling behaviour has come to the fore. Lynsey is going to examine some of the historic cases and how conduct is treated generally in financial remedy cases. Richard's going to talk through some of the other aspects of coercive controlling behaviour that has impact outside of the pure financial remedy awards, but for instance in postnuptial agreements. Chris is going to have a look at how the court is likely to test whether or not conduct can be satisfied by coercive and controlling behaviour and look at some of the impact of that. And then finally, Sassa is going to have a talk through some of the cases that we might be dealing with and how we might factor in coercive or controlling behaviour or not. And what we hope to do then is have a conversation between us, and we hope that you'll find this interesting, is whether or not this is actually going to have any material difference to how we practice financial remedy cases. Is it really going to feature? And if it is, how are we going to manage it? So that's the menu for today. I'm just going to touch on, as I indicated earlier, about the more recent cases, which I know you'll all be familiar with. The Court of Appeal case in Re H&N, and followed afterwards by the High Court decision of Mr. Justice Poole in Re JK. This is obviously a field that we're not particularly specialists in. We're financial remedy practitioners, but we couldn't have ignored the Re H&N cases. It was, as you know, a string of 4 cases all put together in the Court of Appeal to assess the effect of domestic violence, but particularly allegations of coercive or controlling behaviour. And the Court of Appeal had a look at what it meant, how you deal with these allegations, and effectively giving guidance to judges and practitioners about how to deal with cases that involve these kind of allegations. You'll probably remember from Re H&N, it was a pretty strong Court of Appeal. We had the President, Lady Justice King, and Lord Justice Holroyd. Not only were the judges impressive in lineup, but there were also 4 interveners. So apart from the 4 separate cases, we had the first interveners were Cafcas, the second interveners were women's groups, the third interveners, Families Need Fathers, and finally, and perhaps most importantly, the 4th interveners were the Association of Children Lawyers. So the Court of Appeal had a very wide network of submissions assisting the court in coming to the conclusions that they drew. And what, of course, the court was looking at was the subtlety of coercive or controlling behaviour, that this isn't an obvious incident that you can pinpoint and have a hearing about, but this is a pattern of behaviour. And what the Court of Appeal was trying to do was to indicate to us as practitioners and to judges that although this may be a subtle pattern of behaviour, it's important, it's abusive, and we have to look out for it, look for the signs, and then try and deal with those signs in a way which is proportionate and using court time without effectively wasting significant periods of time, particularly in children cases where obviously delay is something that we have to avoid. So, of course, in the case of Re-H&N, they looked at the Practice Direction 12J, which, of course, deals with domestic abuse and identifies what it is. And you'll be familiar with the definition in paragraph 3. Domestic abuse includes any incident or pattern of incidents of controlling, coercive, or threatening behaviour, violence, or abuse. And that's between those aged 16 or over. So you'll remember this was a lowering of the threshold, not now adults, but 16 or over, who've been intimate partners or family members, regardless of gender or sexuality. And this can encompass, but is not limited to, psychological, physical, sexual, financial, or emotional abuse. And domestic abuse also includes culturally specific forms of abuse, including, but not limited to, forced marriage, honour-based violence, dowry-related abuse, and transnational marriage abandonment. So that was the broad definition as set out in the practice direction. What is coercive behaviour? Well, it means an act or a pattern of acts of assault, threats, humiliation, and intimidation, or other abuse. And that's abuse that's used to harm, punish, or frighten the victim. So it's the intention of the abuser and the impact on the victim. What about controlling behaviour? Well, that means an act or pattern of acts designed to make a person subordinate and or dependent by isolating them from sources of support, exploiting their resources and capacities for personal gain, depriving them of the means needed for independence, resistance, and escape, and regulating their everyday behaviour. And as I've mentioned, in Re-H&N, paragraph 32, there was quite a lot of focus on the intention of the perpetrator. What is their motive? And that is something that is not always easy to detect, particularly where you have, as often the cases in these type of situations, narcissistic behaviour. It's very difficult to identify at first, and it can be a subtle and gradual build-up. So much will turn on the intention of the perpetrator of the alleged abuse and the harmful impact on the victim. Re-H&N looked at the practical management of cases involving coercive and controlling behaviour, and you'll know that a great deal of time was spent trying to understand how does the court deal with these allegations. In the context of children law, do you need to have a fact-finding hearing? Now, although Practice Direction 12J focuses on children representation and Children Act issues, the discussion in Re-H&N has some resonance for financial remedy cases, because what H&N looked at was, for instance, do you need a fact-finding hearing? Well, the court needs to ask, is it necessary and proportionate? If it's necessary and proportionate in a Children Act proceeding case, that's a good indicator to us that that's going to be a test in a financial remedy case. And I think it's important that we focus on those two words, necessary and proportionate. And in the children case, in Re-H&N, what the court focused on was look at the allegation and ask two things. Does that have relevance in your assessment of risk? And is it relevant in terms of impact? What is it going to do in terms of causing a problem? And how are we going to deal with that problem to try and fix it? So we're looking at whether it's necessary, whether it's proportionate to examine a case of coercive and controlling behaviour. And to answer those questions, look at the assessment of risk and then look at the impact on the victim. And of course, don't forget the overriding objective, which was focused on in Re-H&N. The court has limited time, limited facilities, and we have to be careful in using those facilities with respect. We can't expect the courts to take days and days examining various allegations. The overriding objective, the road ahead, focusing on proportionate use of court time. Again, focus on whether it's necessary and relevant. Now, in Re-H&N, they looked at other ways of avoiding fact-finding hearings, whether you could have a CAFCAS assessment, whether you could have a threshold criteria, pleadings, and so on. Again, this is something that we might want to think about in a financial remedy case, and I suspect that we'll hear more about that from Chris. H&N was followed shortly afterwards by Re-JK, as I've said, Miss Justice Poole. And if you want to have a case to read, which gives you a very clear understanding of how to treat allegations of coercive or controlling behaviour In a Children Act case, that's your go-to judgment. It's a really good read to understand how the courts manage these cases in the context of Children Act applications. But how does that help us in terms of financial remedy? Because of course, Practice Direction 12J is focused specifically on child arrangements. It is not a freestanding jurisdiction. And this is something that was commented on in We H&N. At paragraph 58, the court said it does not establish a freestanding jurisdiction to determine domestic abuse allegations which are not relevant to the determination of child welfare issues. So Practice Direction 12J is not our doorway into dealing with coercive or controlling behaviour in the financial remedy jurisdiction. That's specific for Children Act. But it is an indicator, as I've mentioned earlier, of how the courts may treat financial remedy cases where there are allegations of controlling or coercive behaviour. So let's apply the same test. Is it necessary? Is it relevant? Is it proportionate? In the Children Act context, the reason we ask these questions is because there is going to be a continuing relationship between the abuser and the child. There is, the court is trying to ensure that the child has the right to relationship with an abusive parent. But of course, the court has to understand the level of risk. There is an ongoing relationship. That's why the court must look at this coercive and controlling behaviour. In financial remedy proceedings, we have different goals. First of all, we've been pressing for years now for no-fault divorce. We're not looking and examining in the wardrobe of each other's behaviour over the course of a marriage. Secondly, in financial remedy, we're looking at a clean break. We're looking to cut the relationship. So we're going in a different direction from the Children Act cases. But those three tests, necessary, relevance, and proportion, are still appropriate. And I suspect this is something that we'll come back to in the cases that we've examined historically and the cases hypothetically looking forward. But in a financial remedy case, there are obviously occasions where there is an ongoing relationship. Take, for instance, periodical payments. There will be a nexus between the abuser and the victim for some time. How do we make that relationship safe? That's the relevance. Are there going to be periodical payments orders? It might also make us need to think a bit more laterally about the type of orders we're pursuing. If there is an abusive relationship with this subtle controlling pattern of behaviour, maybe periodical payments is something we want to avoid. We might need to be thinking laterally, not about quantum, but about type of orders. And although we are specifically focusing on financial remedy cases, and we're looking in the context of the Matrimonial Causes Act and conduct under Section 25, this is also going to have an impact on other financial remedy cases, as Richard is going to talk about in the postnuptial cases, but also think about Schedule 1. Often going to have some fairly good anecdotal examples of one partner trying to control the other, and that could go either way. And that may affect the type of orders that the court's going to make. So this is something that we'll come back to. So that's a general introduction on how the coercive and controlling behaviour in the Children Act sphere is now filtering over into the financial remedies sphere. And I'm now going to turn over to Lynsey, and Lynsey is going to talk to us a little bit about the background of the conduct cases in the context of financial remedy.
Thank you, Alexis. I'm going to look at the history of conduct and how it's evolved through the authorities, certainly since the Matrimonial Causes Act in 1973. From the outset of the late 19th century until only recently in April 2022, divorce has been fault-based. And so the conduct of a respondent to a divorce petition has had an important part in the commencement of divorce proceedings. However, the impact of such conduct on financial remedy proceedings has been of limited effect. And as long ago as 1972, in the pre-MCA 1973 case of Wagstaffe, Lord Denning made it clear that the role of conduct would be fundamentally circumscribed. He pointed out that in the vast majority of cases, the imposition of financial penalties ought seldom to find a place. And it was Mr. Justice Ormerod who established the obvious and gross test such that a right-minded member of society would say that the conduct was of a level to justify a reduction or extinction of a party's financial claims. In Miller and Macfarlane, the House of Lords held that conduct arguments should only be raised in truly exceptional cases, to justify either an enhancement of the innocent party's award or a reduction or elimination of the entitlement of the guilty party, but only where it is obvious and gross that it would be inequitable to disregard. And Baroness Hale in that case stated, it is only equitable to take conduct into account if one has been very much more to blame than the other. In referring to the Wagstaffe test, she said it's simply not possible for any outsider to pick over the events of a marriage and decide who was the more to blame for what went wrong, save in the most obvious and gross cases. In that case, Mrs. Miller, as most of you will know, relied on the fact that Mr. Miller had left her for another woman as conduct to justify the court ignoring the short duration of the marriage. She failed in that claim. Over the years, 3 categories of conduct have developed. The first is litigation conduct, which is conduct within the proceedings, which is largely dealt with by way of cost orders. We have marital conduct and we have financial conduct. Given the overall theme of this seminar, I do not propose to discuss litigation conduct, which could be subject to its own seminar, and we'll be focusing on marital conduct and financial conduct. Marital conduct. So conduct arguments in this category are very rarely run, as they are rarely successful. It has been said that the conduct complained of should have nothing to do with the ordinary run of fighting and quarrelling of an unhappy marriage. All of the conduct which has been held to be relevant has been of manifest seriousness. And there's a certain amount of recurrent phraseology in the authorities. Lord Justice Balcombe said in Evans, if the court were in these circumstances not to discharge the order, the public might think that we had taken leave of our senses. Mr. Justice Ormerod in Hall said that the sense of justice required to be taken into account was an important factor. And Mr. Justice Bennett in C&C asked whether it would be repugnant to any sense of justice for the wife to receive any award at all. And it was in S&S, which is a case from 2006, where Mr. Justice Mostyn, who then was counsel, coined the phrase gasp factor, which has remained a relevant test to date. The reported cases on marital conduct tend to fall into 2 categories. We have poor sexual conduct and we have violence. And you should have in your pack a table of conduct cases that we've prepared. It looks something like this. It's quite long and lengthy, but hopefully you can take that away for some bedtime reading if you're bored one evening. And I'm not going to focus on all the cases there because there are plenty, but simply going to highlight a few relevant ones. In respect of poor sexual conduct, adultery is generally insufficient. And certainly the early cases in respect of adultery are largely going to be irrelevant and rather historic now. There is a case in 1983 called Bailey and Tolliday, where the wife had a long-standing affair with the husband's father, and she bore a daughter by the father-in-law, yet deceived the husband into thinking that this little girl was his. And in that case, her share in the family home, which was determined to be about 60%, was reduced to 30%. And I just pose a question whether that sort of conduct would today pass the gasp factor as it did in 1983. And that's something perhaps we can discuss later. There is another case from 1982 in which there had been, the respondent had committed incest with children, and that was determined a relevant conduct case. And most recently, and I think this is an important case to flag up, is K&L. It was a Court of Appeal case from 2010. It was a case in which the wife was married, it was her second marriage, and she had 3 adult children. The husband was found guilty, or he pleaded guilty to sexually assaulting the wife's grandchildren, and he was sentenced to prison for 3 years. He had also taken indecent photographs of these children and had shared the children's names in online paedophile sites. In that case, the wife was worth approximately 4.3 million. It was all non-matrimonial wealth. And there was a small property abroad that the parties owned jointly, the husband's share of which was worth about £90,000. And the husband sought a needs-based award of £500,000 on the basis that's what he would need when he was released from prison. The court awarded him £100,000, which was essentially his share in the foreign property. And then they ordered him to pay the wife's costs of £50,000, leaving him with a very small amount. And on appeal, it was concluded that his conduct was relevant alongside the non-matrimonial nature of the wife's wealth. There was also the factor that the husband had imminent inheritance prospects. But very importantly, during the marriage, there had been a separation. And following that separation, the parties reconciled. But the reconciliation was based on a promise the husband gave that he would not take advantage of the wife's greater wealth. And it was that promise that led to the reconciliation, without which the husband would not have had the opportunity to sexually assault the grandchildren. And so the court said that there are a number of factors that justified the award that was made. The impact in this case, and the reason I flag it, is the impact was substantial on the family, but it was of a non-financial nature. So certainly the relationship between the wife and her children and her grandchildren had been affected. And there was the conduct was described as so appalling, and its legacy of misery has been so profound as plainly to have entitled the judge to reach the decision that he made. We then look at violence, and again, physical violence must be extreme. That's what the case law has told us. And there are various cases where a financial adjustment has been made as a result of the violent conduct of one party. One of those cases is Jones and Jones in 1976, where the husband attacked the wife with a knife after decree absolute. He inflicted wounds, causing 75% disability to one of her hands. She was a nurse and she could no longer work. He was convicted to GBH and sentenced to 3 years in prison. And the wife, as a result, received 100% of the family home, the court concluding that her future employment prospects were doubtful as a result of the attack. Another case was Kite and Kite in 1988. In that case, the husband suffered manic depression and caused the wife to suffer much unhappiness. However, on the 2 occasions when he attempted suicide, rather than trying to stop him, the wife either did nothing or provided him with the alcohol and drugs to facilitate the suicide. She was awarded a reduced capital settlement as a result of her conduct. In 1989, Evans and Evans, the parties divorced in 1953. But in 1985, the wife was convicted of inciting others to murder the husband, for which she was sentenced to 4 years in prison. As a result, the court discharged the ongoing periodical payments order, finding it unrealistic and unjust the husband to continue to pay the wife periodical payments, which he had meticulously kept up for over 35 years when she'd been convicted of soliciting others to murder him. In H&H in 1994, the husband was imprisoned for serious assault and attempted rape of the wife post-separation, for which she was hospitalized. He was dismissed from employment, and the fact that he could therefore no longer financially support the wife was a relevant factor, and she received all the equity in the family home, leaving him with a stereo and some paintings and a small pension. And finally, in 2005, post-separation, in the case of H&H, the husband was convicted of attempted murder of the wife. It was a very violent attack in the family home in the presence of the 2 young children, and he was sentenced to 12 years in prison. The wife was formerly a police officer, but she was unable to work after the incident. And this was described as conduct at the very top end of the scale. As a result, it had a magnifying factor when considering the other Section 25(2) factors, especially the wife's needs. It also affected her mental health, it destroyed her earning capacity, and it was likely to impact the children in later years and deprived her of any support from the husband for many years while he was in prison. So she received 100% of the family home and the bulk of the other assets. Violent conduct, however, does not always lead to a much reduced award or indeed any reduction at all. And again, it's all going to be fact specific. In Hall and Hall in 1984, post-separation, the wife stabbed the husband in the abdomen during the course of an argument. There were no assets in that case, but the wife was still awarded just under a third of the husband's income by way of periodical payments. There was a discount of that amount on account of the conduct that she had inflicted on him. On appeal, the court found the quantum was reasonable, taking into account all the Section 25 factors, regardless of whether there had been conduct or not. And then in M&M in 1982, the wife killed the 2 children of the marriage. She was found not guilty by reason of insanity. If there had been no question of conduct, she would have received 50% of the family home and ongoing periodical payments. The court still gave her 50% of the home, but only awarded her £1,000 towards a clean break, having regard to the hardship that had been suffered by the husband. There is one other case that doesn't quite fit into the violent category of cases, but is relevant in terms of marital conduct. And that is the case of Clark in 1999. It's the case I always use when trying to advise my clients as to whether the conduct in their case is relevant. And this was where a woman married a husband who was 36 years older than her. She never allowed him to consummate the marriage, refused to live with him apart from a 1-year period, which was used as an inducement to secure his retraction of a divorce petition. And she kept him as a prisoner. At various times, he was relegated to a caravan in the garden, a nursing home, or an annex in the family home. She also persuaded him to transfer various assets to her sole name, which she had squandered and mismanaged. And after a 6-year marriage, where there were £2.5 million worth of assets, she received only £175,000. And so that is another example of marital conduct. Where such conduct is found, how is it to be reflected in outcome? Even where the conduct is obvious and gross, the court's role is not to act as a moral arbiter. It's not acting as a criminal court. It should not be punitive or confiscatory for its own sake. And in H&H, the attempted murder case, Mr. Justice Coleridge said that conduct should be considered as a potential magnifying factor. He said it is the glass through which other factors are considered. So it may be the reason the court is not persuaded to move away from equality, where otherwise there may have been a good reason to do so, or vice versa. It may be more generous to the needs of an applicant because of the finding of such conduct. In a recent judgment of OG and AG, which was only in 2020, Mr. Justice Mostyn said that such marital conduct will only be taken into account in very rare circumstances and will only be reflected where it has a financial consequence. Of course, it's difficult where there is marital conduct to assess how to attribute a financial value or impact arising from such personal conduct. It's easier where it can be quantified, for example, where a party's earning capacity has been reduced to zero as a consequence of the conduct. But I'm not sure I agree with Mr. Justice Mostyn in his comments that it will only be reflected where there is a financial consequence, because clearly there are cases such as K&L where there was no financial consequence as a result of the husband's indecent assault on the grandchildren, but that did sound in a different award for the husband. In your pack, you will have a whole selection of cases that reference the impact of financial conduct. Again, given we're dealing with coercive and controlling behaviour, I feel that matrimonial conduct or marital conduct is more relevant. And so I'm going to pause there. But obviously refer to your pack for the relevant information in respect of add-backs and how they are applied in today's courts. Thank you.
I'm going to talk today just very briefly about the case of Trahan and Lim, which is one of the most recent and probably only financial cases that actually does involve specifically allegations of coercive and controlling behaviour. It's in the context of nuptial agreements, and in particular, one can see that allegations, if made out, could indeed have an impact on the outcome. One of the interesting spin-offs, of course, of the fact that the intention behind agreements was to hopefully make things a lot more simple and straightforward for parties when they came to divorce or separate. The law of unintended consequences, of course, has meant there is a whole spin-off series of arguments where one of the parties tries to get out of that argument, be it a post-nuptial agreement or a prenuptial agreement. In the Trahan case, the allegation was in relation to a post-nuptial agreement that over many, many years there had been coercive and controlling behaviour, such that Ms. Trahan herself was suffering from post-traumatic stress disorder, to the extent that she said that she really did not have self-autonomy when signing the agreement, and that was therefore a vitiating circumstance in relation to the agreement by reference really to duress or unconscionable behaviour, which under the law as we knew it certainly before Trahan was one of the vitiating circumstances following the Edgar arguments. In Trahan, of course, it is the case that Sir Jonathan Cohen decided that Edgar was in fact still good law. What we have here is a term of coercive and controlling behaviour, which might be a new term but in itself, the harm behind it is nothing new. And Sir Jonathan quoted, of course, by saying that if Lord Justice Ormerod had been writing his judgment today, some 40 years after Edgar, he may well have used the term coercive and controlling behaviour rather than duress, or perhaps in addition to duress. A couple of practical points to consider which might be of interest though in relation to this particular case and how it might impact on others is that one of the very first issues that arose was the question of participation directions and the extent to which one or both parties should not be seen by the other at various stages within the proceedings. The case, in fact, was managed by Mr. Justice Mostyn all the way throughout, right up until the final hearing before Sir Jonathan Cohen. And a problem, perhaps that I put it neutrally, that we all face is that as soon as somebody raises an allegation of coercive and controlling behaviour, if you are defending those allegations, you are perhaps immediately on the receiving end of an application for participation directions, whereby it said that you should not be seen on a screen if it's a remote hearing, or that you should be behind a curtain if it's a face-to-face hearing. And in relation to that, in this particular case, it was decided that really the children approach of using PD 12J was really largely the best guidance that one could get in terms of the sort of steps that ought to be taken. It's very difficult, of course, for a defendant in those circumstances to do anything other than to go along with what's being suggested, because the allegation soon arises that if you say, well, I shouldn't be hidden behind the screen, or I shouldn't be have my camera switched off, you're immediately accused of being abusive, which is something of a circular argument, not to trivialize the matter, but there is a need in these cases for really careful case management from the very outset as to whether there really is something. Is there prima facie evidence of coercive and controlling behaviour, or is this something that really doesn't amount to very much? Another interesting thing that we may have time to talk about is reporting restrictions and publicity. The lack of publicity in the past, of course, has meant that most people haven't found out about these sorts of allegations being pursued in cases, except in the most exceptional circumstances. Here, of course, because the courts are open to the press soon got hold of the information that one of the parties in this case was a judge. And they soon got hold of the information that the allegations were of coercive and controlling behaviour. And of course, that is a matter that is not only of actually interest to the public, but arguably in the public interest as well, which is the test. But what does one do when a series of allegations are made but denied? In this particular case, perhaps, if I may say so, the right balance was struck, is that there was an absolute reporting restriction until the end of the hearing and the judgment was actually made. And if I may say so, that was right, because of course the reality is that the press will get hold of allegations and report allegations day by day in the newspaper, and might lose track of the fact that at the end of them, as actually was the case in Trahan, that those allegations were dismissed as not being made out. And it does seem to me that that potentially would have led to some really serious injustice. Just thinking very briefly, though, about coercive and controlling behaviour and these sorts of agreements, particularly the post-nuptial ones, it must be right that they are capable of being a vitiating factor. One can see circumstances in which somebody is so worn down, so browbeaten, that they will do more or less anything that they are told to do. And it's something that should be taken very, very seriously. However, solicitors or lawyers generally do need to be very, very careful I suggest, in considering the demeanour of their client whilst advising on prenuptial and postnuptial agreements, because it might be said, well, you've missed a clue here. Your client's been telling you about things. You haven't made a careful note of it. You have not made a note of what might traditionally have been called domestic violence that could be a vitiating factor. And so I suggest it is very, very careful care that needs being taken when you're keeping your attendance note on your file. In a sense, of course, one might say that experienced lawyers know the signs of coercive and controlling behaviour when they see it. And just I suggest keep an eye out for it and make a note in the circumstances. The unfortunate fact, it seems to me, is that currently the allegation of coercive and controlling behaviour, whilst not belittling it in any way, is appearing everywhere. It's appearing in children cases, and it's beginning to appear in financial cases as well. And my suggestion would be that at a very, very early stage, a court has got to make a clear assessment as to whether it is likely to make a difference if the allegations are made out, because it is the causation, to my mind, at least, that's all important here. And it might not be necessary or proportionate to even consider the issue if one considers that even if these allegations were made out, it could make no difference to the outcome. In those circumstances, should the court really be considering it at all, giving vent to publicity, giving vent to anger, adding to costs? I'd suggest not.
Thanks, Richard. I'd like to pick up on that thought and explore it a little. When Alexis was dealing with Re-H&N, the thought that occurred to me is that in the children's sphere, the Court of Appeals, the essence of the Court of Appeals decision was to say, this is happening in certain cases. It is a real thing. We need to think about how and consider carefully how this impacts upon the decisions that courts are making in the best interests of the child. So it is something that they are alert to as a societal problem. It doesn't necessarily follow that coercive control creates a societal problem in the same way within the specific confines of the financial remedies jurisdiction. And it seems to me that perhaps one of the takeaway points of this is to draw a distinction in financial remedy cases between those cases where it's likely to make a difference for one reason or other. And Richard has just touched upon the parties' effective consent to a pre or a post-nuptial agreement. And one can think of other situations, for instance, entry into an agreement that is said to be a Zidias case or something of that nature, where one can easily see that a pattern of coercive and controlling behaviour might well make a big difference to a party's willingness to enter into a disadvantageous transaction. On the other hand, does it follow from that, and picking up on what Lynsey was talking about in terms of conduct cases generally, does it follow that coercive and controlling behaviour is a quantum factor within the meaning of Section 25G? And it seems to me that that is a real debating point that we need to focus on and draw the distinction between those two situations, one where it might make a difference to for instance, the type of order. Do you have a periodical payments order in favour of somebody who was the victim of a coercive and controlling relationship? On the other hand, does it make a difference to the quantum of the overall financial package that applicant receives? And it seems to me, as I say, that we do need to draw that distinction. And in particular, as Lynsey said, the test on what satisfies the conduct that it will be inequitable to disregard it threshold has been set at a high level and has been consistently applied at a high level for 50 years. The courts are not changing that gross and obvious test in a hurry. I'll just mention one particular tangential point in relation to that, which is the case of Miller that Lynsey also picked up on. In Miller, what happened at first instance was that Mr. Justice Singer said that the reason why the husband prayed in aid of the shortness of the marriage, and Mr. Justice Singer said the wife had an expectation that she would be living at a significantly higher standard of living than she would otherwise be able to, and that legitimate expectation was dashed effectively as a result of the husband's conduct. Now, the House of Lords was having none of that, and in particular, Lord Nichols made the point that Parliament has set the test as being conduct it would be inequitable to disregard, and that has been construed as meaning something that's gross and obvious. Once you've set the threshold at that level, the courts can't, and as I say, that's a matter of statutory construction. The courts can't undermine that by saying, well, there's different evidence here that we'll take into account under the rubric of all the circumstances of the case, even though it doesn't clear the threshold of gross and obvious. So the takeaway point from Miller, it seems to me, in this context, is that either you clear that same gross and obvious threshold, as was discussed, the gasp factor, or it's not relevant. Those are the only two possibilities. And it seems to me that there are many, many cases where undoubtedly a pattern of coercive and controlling behaviour could be established on the merits, but whether, like domestic violence, for instance, that clears the gross and obvious threshold is extremely debatable. That said, the language of the Act is clear. It permits the court and requires the court to take into account in an appropriate case conduct if it would, in the opinion of the court, be inequitable to disregard it. And that is, of course, an entirely fact-specific exercise. There is no reason in principle why a pattern of coercive controlling behaviour cannot satisfy that statutory threshold. Whether it will do is, as I say, entirely fact-dependent. Which brings me on to discuss, to think about some of the problems that you will have if you are pursuing a case in terms of section 25(2)(g) to say that this pattern of behaviour amounts to conduct. I want to think, first of all, about the evidence that you might need. And of course, this again is fact dependent. So I just want to posit some examples and think about what would need to be established to get over the section 25(2)(g) threshold. And going back to Alexis's point about the evidence, it has to be necessary, it has to be relevant, and it has to be proportionate. All of those questions fall to be resolved in the light of the circumstances of the particular case. But that is where the devil in this is going very much, I think, in the detail. Take an example, take the following example. The allegation is made that over the course of a 20-year marriage, there have been regular, frequent, constant exchanges between a husband and a wife where, let's assume that the guilty party is the husband. He has belittled her constantly. He has generally worn her down, and he has exercised controlling and coercive behavior over a very, very long period of time. So what you are basically doing is you are saying, I need to refer to a 20-year pattern of behavior to get this claim over the conduct threshold. Now, in terms of what's proportionate, I can see an awful lot of judges being extremely concerned about the level of evidence, the quantum of the evidence that you would need to establish that. If you think about a domestic violence case, and your argument was there has been a pattern of domestic violence over 20 years, then it may not necessarily be necessary to demonstrate throughout that 20-year period that there has been domestic violence. Does the same logic apply to coercive and controlling behaviour? Arguably not, but there may be circumstances where it is. And as I say, thinking about the evidence that you need to establish the particular allegation that is made of coercive and controlling behaviour might well take you to the point where the likely impact upon the outcome is not worth a candle. So in terms of proportionality, I think that there are real issues for the profession to be alert to. Also in terms of relevance. There are cases, and sorry, Lynsey, which was the case where the chap was excluded from the family home? Clark. In a case like Clark, it's relatively straightforward to say this is what actually happens and this is the conduct that I can complain of. And one can easily imagine that in the Section 25 statement, it wouldn't be too disproportionate or too onerous to be able to deal with that. As I say, there are other cases, there are going to be other cases where the control is far more subtle than that, and the behaviour that is complained of is less egregious, but has nonetheless had a similar effect over a long term. And it's those cases that trouble me. Another point that in terms of the evidence threshold is the difficulty that you will actually have in establishing some nexus between the conduct complained of and the outcome. Lynsey was talking earlier about the Mostyn line of reasoning, which is basically conduct isn't relevant until unless it has a financial consequence. How do you prove, setting aside for one moment Lynsey's point that might not be a sound proposition of law, how do you prove necessarily, on the balance of probabilities even, that a financial consequence flows from the particular conduct? So for instance, let's say you have a pattern of coercive controlling behaviour that involves the wife. Again, I'm being very sexist and assuming it's always the husband who is the guilty party and always the wife who's the victim. But let's just continue that assumption. The husband subjects the wife to his control to the point where she has no voice of her own in relation to any financial decisions. The financial base that the court is concerned with is at the conclusion of the marriage, X. To what extent might it be said that the reason why the asset base is X is as a result of that controlling behaviour? Because having given himself a free hand to exercise utter control over the family finances, he actually did quite well with them. So that seems to me to be a particular evidential problem that is likely to arise in cases where what is being complained about is that one party's financial independence has been subjugated to the will of the other. There are all sorts of other examples of cases where you might say that controlling behaviour has a particular relevance, but then the problem might be demonstrating that. And perhaps we can think about some of those when we have a discussion shortly. Again, returning to something that Lynsey said, one point of statutory construction that I think is absolutely clear is in relation to the distinction between litigation conduct, which we're not going to go into, and conduct within the marriage itself. And there's a line of cases in the 90s. An example would be a case called Tavallarius, and I think Young and Young was another one, where the Court of Appeal held that conduct in the litigation sense was something that sounded in costs and wasn't relevant to the Section 25 exercise, in particular Section 25(2)(g). It strikes me that if you are dealing with coercive and controlling behaviour as a quantum factor within the meaning of Section 25(2)(g), and as I say, there's no reason in principle why you shouldn't, but the manifestation of that is not necessarily limited to what happened during the marriage. It may continue to manifest itself in litigation conduct. I think probably the way to interpret those decisions in the light of this particular line of argument is probably this. that the conduct that is relevant for the purposes of section 25(2)(g) is the conduct that took place during the marriage. But in evidencing what happened during the marriage, it is permissible to look at what has happened outside the marriage, and in particular, in the course of the litigation. So in the same way that a dishonest husband, for the purposes of his disclosure, for instance, one might refer to other acts of dishonesty of the marriage. Were you having an affair? No, that wasn't true, was it? And that impacts upon your credibility, which I'm going to ask the court to take into account when thinking about the extent to which you breached the duty of full and frank disclosure. One sees that, in a relatively on a relatively common, frequent basis. So I suspect that even though the impact per se of litigation conduct will be in relation to costs rather than as a quantum factor, the litigation conduct complained of may well be something that evidences conduct during the marriage. The last point that I want to make is that I suspect that to the extent that there will be any attempt to increase the number of conduct cases as opposed to thinking about coercive control as a reason for making a difference order or as a reason for disturbing something that a party appears to have consented to, or not, as the case may be, it seems to me that the courts are likely to be quite resistant in the same way that they have been resistant to all the other attempts to erode or undermine the high threshold. So, for instance, one goes back to the early days after White and White, and there was an argument that was curtailed quite quickly about contributions, and I think it was Coleridge, Mr. Justice Coleridge, who made the point in a number of decisions that conduct and contributions are opposite sides of the same coin. And if you are trying to point towards a specific contribution that you have made, really what you are doing is exposing the court to an attempt to retrospectively trawl through various things that have happened during the course of a marriage in the same way that you are doing with a conduct allegation. And the courts long resisted the temptation, as the phrase is used in the authorities, to go rummaging through the attic of a failed marriage. And one can see exactly the same, exactly the same reasoning will be brought to bear here. Domestic violence is a real societal problem. In how many cases does domestic violence feature as a quantum factor in the conduct sense? Very, very, very few. One suspects that coercive control is likely to encounter the same resistance from the judges to allow the floodgates, if I can put it that way, to open. That, as I say, is not to say that in an appropriate case, coercive control can't be a quantum factor in the section 25(2)(g) sense. But I very, very, very much doubt that the courts will be willing to water down the very high threshold that a litigant needs to clear in order to persuade the court that it is a relevant factor. Thank you.
Thank you, Chris. I agree with Chris. I think we all would agree with Chris that domestic violence is a societal problem. And yet we see that societal problem rarely reflected within the conduct cases. And I think we all need to be cognizant that if we are going to raise arguments of coercive controlling behaviour, we will encounter the same hurdles that litigants encounter when they're attempting to argue that domestic violence is a form of conduct. And we all have those very difficult experiences of effectively saying to our clients, well, you've suffered, but I'm afraid you've not quite suffered enough to meet the bar to open up an argument as to conduct. But at the commencement, Alexis posed two questions. And the first question she posed is whether or not coercive controlling behaviour could amount to conduct within section 25(2)(g). I think the theoretical answer to that is yes. And we need look no further than the case of Mr. Justice Mostyn, which Lynsey dealt with, OG and AG. And in that case, after considering at paragraph 34, gross and obvious personal misconduct, Mr. Justice Mostyn said something very interesting. What he said at paragraph 35 was, the conduct under this head can extend obviously to economic misconduct such as is alleged in this case. If one party economically oppresses the other for selfish or malicious reasons, then, provided the high standard of inequitable to disregard is met, it may be reflected in the substantive award. However, the second question that Alexis posed is, will that make a material difference? But my view is that it's very difficult to answer yes to that for all the reasons that Chris has explained in terms of the evidential burden and the very high threshold, which is why very much in my view, picking up on the theme that both Alexis, Richard, and indeed Chris and Lynsey have explored, the real material difference may be in terms of the form of order rather than quantum of order, which is why it remains a matter which all practitioners need to be alive to. And stepping back, one of the matters I looked at and want to emphasise is that the concept, the issues, the harm that we are dealing with are not new concepts. This is not new harm. Arguably, the labels are new, and unarguably, our awareness is higher. But I looked at what I might term a rather old case now of B&B, Measure Order 2003 2FLR 285. And this was Mr. Justice Mumby, as he then was, sitting and hearing an appeal from Deputy District Judge Wilborn. And in that case, the Deputy District Judge at first instance had found that the husband's forensic pursuit of allegations, effectively allegations that he'd had been entrapped into the conception of a child and that the wife was cohabiting, were relevant to the issue of the measure order. And what the Deputy District Judge found was that she declined to make a measure order in the husband's favour on the basis that such an order would leave the wife in fear of observation by the husband to see whether he could realise his charge. And Mr. Justice Mumby considered that. In fact, in this case, he did overturn the decision at first instance, and he did so on this basis. He explored how Deputy District Judge Wilborn had reached her conclusion as to the measure and explained that her reason was the wife needs to have the security of knowing that she has a permanent roof over her head, and that of wife without always fearing that the husband is keeping her under observation to see whether he can apply to have his charge realised this year or the next. I find this is a real risk in this case, given the husband's actions in the case of keeping the wife and her friends under such close scrutiny, an exercise in which he has even involved his friends. Mr. Justice Mumby did not interfere with that reasoning, as one would expect of an appellate court, but his concern was that the triggers imposed by the Deputy District Judge, which were triggers as to the child's 18th birthday and remarriage, were such that they argued against any prospect of observation of the wife or former wife on a constant basis. And he actually found that if cohabitation had been included as a trigger, then the judge's findings as to the husband's behaviour would, he said, I accept, be a very powerful one to mitigate against a trigger charge and indeed a measure. And I paused to consider that case because it seemed to me that the concepts, the terminology is different. We're not, coercive controlling behaviour was not the terminology, but the harm was absolutely the same as we're considering now. And one may well say that Deputy District Judge Wilborn, all those years ago, 19 years ago, was rather ahead of where other practitioners had been. And the question I pose for all of you is, given our better understanding now, that Deputy District Judge's findings and conclusions that the wife needs to have the security of knowledge that she has a permanent roof over her head without fearing that the husband is keeping her under observation, whether that is going to have greater resonance in the cases that we do, moving aside from measures. I particularly think about school fees payments. I particularly think about periodical payments orders that my colleagues have picked up on. And I also picked up on from that case, again, maybe Mr. Justice Mumby was ahead of all of us, when he actually particularly referenced that if cohabitation had been a trigger, then the judge's findings would be a powerful findings as to reasons why there perhaps should not be a measure. And so the harm we're dealing with is not new. The concepts we're dealing with perhaps are newer, and more importantly, with our increased understanding and cognizance of these issues, we're all grappling as to how best to advise our clients, whichever side, whether we're advising the party who has been the victim of such behaviours or alleged victim, or whether we are advising the perpetrator. And one of the difficulties, it seems to me, in terms of coercive controlling behaviour is the gasp factor test. And it seems to me that the courts are very slow to understand that a pattern of behaviours, which if an individual or isolated incident would not ordinarily be reflected within a conduct award, should be reflected within a conduct award, because the pattern is to an extent that the gasp factor has been reached. And that again feeds into the very pertinent and very good and difficult points that Chris has raised in relation to both the threshold and the evidence that's required. So where does that take us? Well, moving back to really where I started, my belief that we don't simply discard the allegations, and there needs to be, in my view, a proper grappling with these concepts by the appellate court as to whether one is actually dealing with section 25 2G conduct, whether one is dealing with another circumstance of the case which changes the form of order, or whether the courts need to consider again the threshold. I think that's incredibly unlikely. But consider the scope of the evidence required to meet that threshold test, particularly when one is not looking at isolated incidents in themselves, which would meet the threshold, but one is looking at a pattern of behaviour. And in my view, there are three real issues that the appellate courts need to grapple with. I say the appellate courts, we all need to grapple with them, but they're the appellate courts for a reason. The first is the matter which has always been touched on by my colleagues, the difficulty in attributing a monetary award to conduct that has no identifiable financial impact. But if that's a reason not to do it, as Lynsey has demonstrated, when you see her very helpful pack of cases, you will see there are cases where there is no identifiable financial impact, and yet it still reaches the gasp factor of conduct. The second aspect is a matter dealt with by Alexis arising from the Children Act cases. The focus on the intention of the perpetrator. Now, that is a clear evidential difficulty, and I would argue a societal difficulty as well. And thirdly, the point of necessity, proportionality, and the tension of that test with the overriding objective. And we know the scarce resources of the courts. And as all my colleagues have picked up on, if one is going to trawl through a pattern of behaviour, it matters not whether it's 5, 10, 15, 20, 30 years of marriage, it is going to lead to an extension of the evidence before the court. It may well lead to the admission of evidence from witnesses other than the husband and the wife, and we all know the courts are loath to do that. And I think we can all guarantee it is going to lead to an extension of the time estimate for final hearings, and I would argue an extension of the adversarial nature of the process in which we are engaged. So those are the difficulties. So what are the options for practitioners? For me, the obvious option is the argument that there should be capitalised periodical payments instead of ongoing periodical payments, and indeed a capitalised school fees fund. Now, we know there's an emphasis on the clean break, but we all see those cases where the court takes the view, well, there isn't quite enough money to push to a capitalised periodical payments fund. Arguments of coercive controlling behaviour, in my view, are going to assist when the court looks at it, be it under a conduct limb or in all the circumstances of the case, this idea of it being a magnifying feature through which you reflect the form of the order. Obviously, we've dealt with the measure, and I think that's very much an open door to dealing with both the fact of a measure and the terms of a measure, although I haven't seen a measure in a case for some considerable time. I don't know whether they've fallen out of fashion or just I've fallen out of fashion in the cases that I'm undertaking. The obvious cases where there are postnups and prenups that Richard has dealt with. Another aspect, it seemed to me, is an argument as to the rejection or significant curtailment of the ongoing disclosure obligations, to include both the ongoing obligation to provide financial information and indeed updates from a non-working spouse as to the efforts they've taken to obtain employment or when and if they form employment. Because with an increasing focus on income and earning capacity, particularly for the non-working party, which I endorse, I think that's perfectly proper, in line with the authorities and in line with statute. It's beginning to creep into judgments and it's beginning to creep into orders, a recital or recording that the non-working party to keep the other informed if they obtain employment. And we've seen for a long time the argument amongst practitioners as to whether or not there should be ongoing disclosure obligations, usually from the stronger economic party in terms of P60s, tax returns, and that particularly arises where one has some form of percentage of a periodical payments award. But it seems to me that's another aspect. And finally, and again, Alexis touched on it very briefly, in Schedule 1 applications. Now, I pause there. We all know that Schedule 1 is not actually one of those listed matters. Conduct is not actually one of those listed matters within Schedule 1. Baker J dealt with this as long ago as 2014 and O&P number 2, 2014 EWHC 2225, where he's absolutely clear that under Schedule 1, where a court is required to have regard to all the circumstances of the case, that opens the door to conduct arguments. And he said something very interesting. He said, not because conduct by itself justifies a higher sum being paid in respect of S, but because it has had a profound impact on the life and lifestyle of S and her mother. So you can limb of some form of financial consequence. And indeed, in that case, it was the father was found guilty of inciting others to kill the mother. And finally, in relation to Schedule 1 on this whistle-stop tour, there's a recent decision of Mr. Justice Mostyn in AS and FM 2021 EWFC 2, which I know is much debated by practitioners as to whether it is an appropriate exposition of the law. But Mr. Justice Mostyn was absolutely clear that where the application is to vary periodical payments in favour of a child of the family, then there is power to award a lump sum. And I know that that is being, as I say, hotly debated by those of us that don't have much of a life. Mr. Justice Mostyn was clear to say that it would remain a very rare bird. And my argument would be, increasingly, as we're beginning to understand the extent of coercive controlling behaviour within society, the impact of coercive controlling behaviour, and as we're beginning to grapple with how that should feature in both financial remedy cases and Schedule 1, in my view, the way to answer it is that capitalised awards, including a child maintenance, should not be such a very rare bird. Thank you.
I'm going to kickstart the discussion by throwing a curveball in, and it's this. We've all, I think, aligned ourselves with the general proposition that you are going to find it very difficult, absent a really, really strong case, to rely upon coercive control as a quantum factor. It is more likely to sound in questions of the should there be a lump sum by way of capitalised maintenance rather than ongoing PPs and things of that nature. The problem, it occurs to me as Sassa was speaking, is this. Section 25 says, in considering whether to exercise its powers, and if so, in what manner, the court shall have regard to, and we all know the rest. So in other words, the statute says to the court, not only is this relevant to quantum, but it's also relevant to how you exercise your powers. And in particular, the threshold of gross and obvious that is nailed onto conduct is a threshold of gross and obvious, whether that features as a quantum factor or whether that features in terms of how the court is going to exercise its power. Now, I instinctively take the view that it is one thing to say this is, for these reasons, the applicant's award should be higher or lower, as the case may be. It's another thing to say, for these reasons, the order should be X rather than Y. I'm not sure how I justify that, bearing in mind the language of the Act that we all know. I'd be grateful to see what anyone else's opinion is on that.
I'll take a different view. I think what we've all recognised and we've seen from H&N is that sometimes the subtlety of coercive controlling behaviour gets missed. So we've all got our alarm bells on now and we're all watching for it. What we might be doing wrongly in this lecture and in this discussion is trying to squeeze that behaviour into conduct. It shouldn't be there, in my view. I think if we try and dress it up as conduct, we will never get it past the gasp factor. And that will mean that a serious abuse, which has massive impact on families, will not qualify as a relevant factor. Forget 25 2G. Let's look at all the other aspects of 25. I mean, if somebody is browbeaten throughout the marriage so that, for instance, they haven't got a great income capacity, well, that's going to be tested under the category of financial resources. If somebody's been so abused through the marriage that, for instance, they've got mental health problems, well, of course, we can deal with that under a different arm of Section 25. And I think what we may be tempted to do is to try and dress up what is a subtle behaviour, which is rarely going to constitute the gasp factor. And actually, if it does, you'll think of instances where somebody's been locked in a garage, a bit like the Clark and Clark case in a caravan. I mean, that will obviously give you a gasp factor. You're there anyway. It may be that that's useful if there's no financial consequence, because you do want to get the gasp factor to have some kind of bearing that isn't financially connected. But most of the other coercive controlling behaviour is going to be subtle and probably low level, cumulatively significant, but low level bit by bit. Don't try and drag it into the Section 25G.
On the other hand, and I take that point, but on the other hand, if an applicant has an impaired earning capacity, in a way, it doesn't really matter whether that's the product of 20 years of being browbeaten and having her confidence shattered, or whether it's just that she's been out of the labour market for 20 years. If the evidence demonstrates that her earning capacity is minimal to non-existent, whatever the reasons that bring us to that point, that's where we are, then the court's going to take that into account. And arguing that that's the product of a pattern of controlling behaviour seems to me to be problematic in terms of whether it's proportionate to go down that road.
But then you get this magnifying factor point, that because if you just had the lady been out the earning market for 20 years and therefore had a very low earning capacity, her needs might be X. But if that was as a result of the conduct that had been had happened during the course of a 20-year marriage, then her needs might be X plus something because of the magnifying factor.
But doesn't that take us back to Section 25 2G? Because what you are doing is you are saying, here is something that one party during the marriage did that has a consequence on the other party to the marriage. But the threshold is you don't do that unless you clear the gross and obvious hurdle. And if the conduct doesn't clear the gross and obvious hurdle, you don't take it into account.
Well, that's the first test. Is it necessary? Because even in the children cases, some coercive and controlling behaviour, you only investigate it if it's necessary and relevant. So does that coercive behaviour impact on the child? In a financial remedy case, if there's been years of coercive behaviour, is it necessary to investigate that coercive behaviour if in fact it appears in another head, financial needs or mental
disability
health,
or whatever it may be?
well, actually it may not be necessary, but as practitioners we might want to bring it in anyway, as Lynsey says, because although you might not qualify on the gasp factor, what you may do is magnify the behaviour to just push the judge over the line in getting something that you might not necessarily secure without it.
Suppose you have then, let's say a wife with somebody who's diagnosed them with post-traumatic stress disorder as a result of, let us say, 20 years of pernicious but low-level abuse, coercive and controlling behaviour. That behaviour wouldn't necessarily get the gasp factor. Could you focus it on, well, whatever, it doesn't matter what the causation is, here's post-traumatic stress disorder, which has these consequences, and it is therefore a straightforward need argument. That might be one way of dealing with it.
And two aspects of that, which you just made me think of. The fact that this has gone on for 20 years and that there has been this pernicious level, as you've described, maybe the question we should be asking ourselves is, should that make us gasp? Maybe we are not giving it enough seriousness, and maybe that's partly what H&M is saying. we've got to think about this as an evil, which in a cumulative sense can be really damaging, is of such a level of abuse that we should be holding our breath.
I think
I think you're right. I think the problem we've got, if you look through the cases, the violent cases, they all focus on a one-off extreme event.
Yes.
Not one of them focuses on a pattern of lots of physical domestic violence. So not even in the physical domestic violence sphere, which we've known about and been all very cognizant of for many, many years, is there any authority that says, well, over a pattern of 20 years, this lady is being physically beaten, but not to the extreme level of being, disabled or being stabbed or someone trying to kill her, and that sort of pattern of behaviour hasn't yet found its way into the girls' factor.
It seems to me, Lynsey, one of the real difficulties is we are not a court of moral judgment, but we have conduct, as a separate arm within section 25(2). And I think that does cause a difficulty. In many respects, it feels as if both the statute in respect of that particular arm and indeed the authorities have not caught up with how we are all practicing and what we are all experiencing our clients telling us. Now, I'm not sure whether the one extreme answer to that actually is for the statute to be rectified so that you no longer have conduct as a separate arm and you bring in these arguments through this magnifying sphere of it is a circumstance of the case, and I don't know resolutions approach that, because we do at the moment have this very difficult halfway house where I agree that we are squeezing these types of behaviours into an arm where it might not comfortably fit, and it doesn't comfortably fit with the existing authorities.
But I think when we're looking at the signs of this behaviour, it's also going to impact on cases after the end of the financial remedy. So you're looking at enforcement. And we've all had those cases where you get litigants who repeatedly return to courts with variation applications. And that is often a really clear telltale sign of somebody trying to exert coercive and controlling behaviour after the end of the marriage. And I think, again, that's useful to identify those signs so that when we're giving advice and making submissions to the court, what we're saying is, this is coercive control. You've got to make orders enforcing your original order in a way which protects and prevents that from going on. Well, lots to think about. We could go on forever, as you know. We're very difficult to stop. So we're going to end now and let you get on with the rest of your conference. And I want to say on behalf of all of us, thank you very much for joining us, and I hope you enjoy the rest of the course. Thank you.
Thank you.
Thank you.